With my Lord's permission, my Lord's
Yes.
mention item number 27 and 49.
Yes.
My Lords, these are those West Bengal matters. We had sought accommodation last week. Mr. Sibal is still unwell. He's leading me in the matter. My Lords, I was requesting for some further accommodation. The learned solicitor, we had informed him he's online.
On this ground, I cannot oppose. Subject to my lord, Mr. Sibal's health, if it can be kept on 18th, subject to your lordship's convenience.
18th February?
Yes, my lord, 18th February.
Yes.
18th.
About 18th? Yes. With the consent of the
18th.
parties, post both the matters on 18th.
I'm extremely.
18th.
Yes, 18th.
Obliged, your lord.
Obliged.
One.
Both
Lordships. My lords may kindly see, this is an application I filed. The leave was granted in this petition on 14 to 24 by my lords.
Which matter?
The interim order.
Contempt की फाइल दो, सिविल अपील की फाइल दे दी, लगा contempt.
Yes.
Yes,
Milords,
what is the contempt now?
Milords, what has happened is my lords were kind enough to initially grant status quo, then it was
the orders
confirmed.
passed by the High Court,
Yes,
that is at page 45 and 47.
correct.
High Court says that both the parties did not bring it to the knowledge of the GRT.
Yes.
But I was not, Milords, unfortunately, the respondents were parties. I was not made a party also. Therefore, I went to the High Court.
But
Anyway,
but no.
but
so
the
as to
authority
be
was not
contempt,
informed.
How is it a willful contempt? And ultimately, that order is appealable or amenable to challenge in law. You
But Milords, my lord's order of status quo and leave being granted cannot be modified by revenue authority.
It's only a mutation entry. It doesn't confer any rights.
Correct. I agree, Milords.
And
Milords,
our
when can
orders
I-
will prevail.
Status quo is
Status
for
quo.
possession only. What else?
Correct,
If
Milords. Can I say this,
If
Milords?
they
Can I request this?
on ground, then you come.
Milords, can I request like this,
Milords?
Milords?
Status quo by threatening to dispossess you
Yes.
or create third party interest kind of that, you
Yes.
come, we are not inclined.
Milords, can I say this, Milords? Can I request like this, Milords? Can this be kept along with the main
No,
matter? So,
it will not be kept pending.
Milords, then can
We
I
are
say this?
still on counsel for the petitioner, we are
Milords,
not inclined.
then
to
I'll withdraw it
contempt
this,
petitioner.
Milords.
Yes.
I'll withdraw at this stage
Yes.
to raise my objections
What
at an
is the
appropriate
stage?
stage.
If today it is not contempt, tomorrow also it will not be contempt.
What are
No, if
If he's same.
Okay.
Petitioner. If they do any other act which amounts to violation of our order, you are still free.
Always.
I'll withdraw on this ground, Milords. Lordship may say so. I'll withdraw on this ground because this is a revenue authority.
Current counsel for the petitioner seeks permission of the court to withdraw the contempt petition at this stage, accordingly dismissed.
Please.
Item 2.
Yes.
My lord, there's some delay in filing this. There's some delay in filing this SLF in line.
391 days.
A case,
Some delay.
there's a case.
Some delay is
Otherwise also-
2 figure, not 3 figure.
Group D employee, my lord. A case
Hmm?
of compulsory retirement, my lord.
Yes.
May see the charges, my lord. Charges are very simple, my lord. One day of unauthorized leave and
Rude behavior, threatening, assaulting, abusing.
Everything, insubordination.
that I've given railway concession forms without permission of the principal.
And rightly set
1,000
aside.
rupees penalty is given, my lord. I was ready to pay the 1,000 rupees penalty which was imposed on the management. My
No,
lord,
it was rightly set aside by the High Court
my
duty.
lord, tribunal has exonerated by going through the
Tribunal acted as if the tribunal is the inquiry officer, which is not permissible and rightly said so by the High Court.
My
Both.
lord, last submission, my lord. Before the learned single judge, the management was ready to settle the matter by offering me some amount, my lord. At least on that point, my lord, because today
No.
I have not received
You
any
should have done it.
benefits after 20.
You should have done it. Before the single judge, you should have done it.
Compulsory retirement, you will otherwise also get retirement benefits.
Until
What is
today, I have not received
Dismissed.
any benefits, my lord.
So that is a separate cause of action.
Dismissed. Delay condone dismiss.
2580 days delay, sir. 2580.
Yes, sir. Well, the respondent number 1 is a post-vesting.
What about the
Delay.
Well, it's a 7 years delay.
Only.
Only.
Not only.
There's a presumption that a man has died if he's not seen for 7 years.
I'm sorry, my lords, but my lords, the
You are also a
the
juristic person, you also died.
departmental changes, my lords. My lords,
Thank you. On the ground of delay, dismissed on the ground of delay.
my lords, the delay, my lords, it is a settled law that the post-vesting
By so and so.
purchasee cannot take the land, my lords.
Why were you
Why you
not
are-
cognizant enough?
And in
Why were you
between,
sleeping?
in a dispute between the respondent number one and other respondents, why state should file SLP?
My lords, because the land was vested with the state in 1982.
No,
my lords, by the
Yes,
Should have been
next,
cognizant.
on the ground of
Right.
delay. 7 years, who will condone?
Item 4. Lordship, in this case, I'm a petitioners are the mortgagee. After that.
You are never recorded as Bhumidhari.
Never.
Lordship, I'm possession law is still.
High Court says,
with us.
and all the authorities say possession is not with you.
Not with you.
Lordship, possession
That is
is with
the-
us. I can show the Lordship in this case what happened. No rejectment.
You are only a mortgagee, you are trying to
Step into the shoes
step
of the
into,
owner.
yes.
Lordship, I'll show. As on today also, there's a latest.
There are
order.
4 concurrent findings, madam. This is 136. There's no
And
question of
see
it.
High Court's finding in para
6,
10 and 11.
12 and 13. Yes.
that you are not in possession.
Lordship, this order is nowhere on the record.
High Court order is on record.
Lordship, not.
Dismissed,
Even
dismissed.
even in the high.
There is nothing, absolutely.
Fine. Lordship,
Yes.
kindly see the count. I'll
A
show
mortgagee
order.
not in possession, dismissed.
Item 5. But
Yes.
no eviction, Lordship, I'm saying.
All right, then.
We are not saying anything. We are not saying
Lordship
anything.
is not able to produce.
We are not directing for your even your eviction. If you are in possession, enjoy it. Yes.
Continue.
Next. Yes.
13, 11 days delay, sir.
I must
17
there's a
days.
delay in filing the SLP minutes.
Yes.
Because the issue is the
Issue is delay,
case was
unexplained delay. That is the issue which you have
Plus-
answered for.
And you are squatting over government land,
Plus the
Tamil
delay-
land, and since long 1993, make way for the panchayat.
may I submit laws.
To manage the
There is
land.
a delay that 13 section title suit is still pending. Now there was an issue with respect to that judgment.
Dismissed on the ground of delay. Yes. Yes, go and fight it out. Water body,
Water
government
body-
wants to use it for public purpose.
I seek permission to withdraw the petition.
Yes.
Well
dismissed
advised.
as withdrawn.
Final order has been passed and I seek liberty.
No liberty at all.
Final order has, it is a.
If you have a liberty in law,
Final order has been passed.
Now passed.
Learned counsel for the petitioner submits that since after passing of the impugn order by the High Court, the writ petition itself has been disposed of. Accordingly, he seeks permission of the court to withdraw the writ petition, withdraw the SLP, as it has become infructuous, with liberty to challenge the main order passed in SLP. Yes, accordingly dismissed with the liberty aforesaid.
Item 7.
Wait, please. The issue before the High Court was only seeking condemnation of delay. High Court
Only-
says the allegation
And
was-
only 8 years delay.
only yes.
Only 8 years delay.
No, but what happens is this, he was suspended. After suspension, the termination order was never communicated.
Thank you.
Only one thing, Your Lordship.
Dismissed 8 years.
But Your Lordship, may please see this what they do is, they initiate a formal inquiry. Formal inquiry is not even contemplated under that. Under the act, they could have initiated department inquiry. There is no department inquiry. What they do is,
You should have challenged that order in.
Yes, next.
Item 8.
Very.
Wait, please, my lord. My lords, I'm aggrieved by the transfer order, my lord.
Oh.
Posted,
Don't work. You can resign.
Yes.
That option is always available to you.
my lords, I'm paying medical bills.
Absolutely
Nah.
nothing. Sorry.
You
We
have
will not entertain SLPs like this.
worked there for 6 years, 2019 to 25.
They Mitra, my lords,
Ah.
there now, my lords, I'm transferred to Jastur.
Yes, Jaspur is also in Chhattisgarh.
You have the option of resigning and continuing whereas per your sweet will.
Yes, sorry, thank you. Dismissed.
Item 9.
My lords, I'm paying a short pass over.
Which matter?
Item 9.
9.
Item 10.
Your Lordship.
Yes.
The concurrent finding has been disturbed in revision on a mere assumption that there is some material on record, some material which the single judge says.
He has never been served. That is the finding of the High Court,
That's the
that the defendant was never served with the summons.
No, Your Lordship, we kindly appreciate this, madam.
What appreciate? You read the order.
Yes. Your Lordships may kindly consider, my lords.
And you participate and convince.
No, the Lordships may kindly consider, my lords. The trial judge says serve. The appellate court serve.
Service by what mode was ever someone sent by ordinary process? Admittedly, no.
No.
Registered courts, they were
No.
The CPC requires service through
First
ordinary
service
process.
through ordinary.
Then
If it fails, then registered.
No,
From day one, you cannot serve by registered mode.
Sometimes the registered process is also refused. That is in your hands.
no, your Lordships may kindly consider what Order 9 Rule 13 stipulates, my lords.
It is only at 40 degrees you will
No, your
still have the
Lordships may
chance to
kindly
prove your
consider
case
this,
in
my
the
lords.
trial.
Kindly consider this, my lords. Postal.
Dismissed.
Thank you.
Dismissed.
Postal
We don't encourage at 40 degrees if the
State amendment
summons is
in
not
this.
served in accordance with CPC. Next.
Item 11. Settle.
Letter adjourned.
Item 12. Item list. Next.
Your letter, probably. You are not aware?
She announced immediately. I don't.
Yes.
In the second cognizance taking order,
What happened after the impugn order?
21/7/25. You have got opportunity to argue on charge, everything. You raise your objections at this stage of charge.
Notice was made returnable in 6 weeks by the High Court. What happened thereafter?
nothing has happened. No,
Nothing to go and convince him.
Go and argue the matter on merits.
Lord, page 47, if my lord may say.
You get a rejection on merit.
8%.
You get
In the
an
order,
order on
in
merit.
the order under challenge in this SLP, the High Court has not decided any list any list or issue between the parties. Therefore, we are not inclined to entertain this SLP accordingly.
Lord, it will be rendered infructuous.
No.
Doesn't matter.
No?
Lord, my
You always have.
question petition would come infructuous, Lord.
You argue that and convince. Yes.
Item 13. Short pass over.
That's item 14. This is a question petition which was not entertained by the High Court.
Rightly so. Application of public records.
But my
You
lord,
can't settle by compromise. Sorry.
And it is not at your switch will. Someday you will do FIR and someday you will compromise.
may I submit, my lords? My
The property of a person, living person, was sold by showing him as dead.
my lords, it was first mutated.
Fabricated mutation entries.
Rightly, it's an offense against the
And
society.
the alas, the name and the parentage is same. My lords, the mutation officers, the Tehsildars, the Patwaris.
You are not being convicted. Go and
Later,
face trial.
on the objections, they reverted and then I entered into the
Dismissed.
compromise.
Dismissed. Nothing.
My lords, may I see, my lords, that the
We have
same
seen that.
No, we have seen. Both of us have seen, and we are on the same page. Yes.
the parentage was seen that created the confusion, my lords.
You
Yes.
have a opportunity of arguing on charge. Go there.
My
Yes,
lords,
next.
investigation is pending, my lords.
So all right, it will charge.
Whenever charge sheet is
Convince the
filed,
IO
yes.
not to file a charge sheet. Thank you.
Item 46.
Well, 3.5 years this under trial has suffered, and both the two portfolio have not disclosed.
You had 7 antecedent. Stabbing,
No, that
CCTV,
is-
eyewitness,
I'll come to
everything
that,
is
no.
there.
But for 4 years he has been suffering. Only 4 witnesses have been examined. 25. Only 4 witnesses have been examined with us in this case.
46 call.
Yes.
46.
Matters.
14.
I'm sorry.
Yes.
Oh. That's so nice.
Yes.
Just a minute.
Yes.
Oh, yeah, this is stabbing. Oh, then it will-
Your lordship will only
Doesn't
hear me for
matter.
3 minutes. my lords.
The trial will be expedited, don't worry.
No, my lords, in 2020.
There is one deceased, one injured.
My lords, I'll come to those
Stabbing
contradictions.
is a very
Deceased-
cowardly offense.
Yes. Deceased and the injured witness is contradicting first
You have
informant.
7 antecedents.
In fact, it seems first informant is involved. He was the rickshaw driver.
Sorry, dismissed.
Sir, your lordship, please hear me
Dismissed.
for 3 minutes.
Dismissed.
No. My only request, my lords, I may be heard.
So you want an order on merits? Prejudicing the trial, please?
No, but at least
We are not convinced, Mr. Counsel.
with
Bail is a matter of discretion, sorry.
my
Thank
only
you.
request is that my submissions may be heard, my lord.
All right, we'll note your submissions then
My lord,
and deal with them. At this stage, you are inviting a conviction order. Do that.
no, my lords, in 2023, High Court had granted me liberty to move Sessions Court if trial is not progressed. I go before the Sessions Court. Sessions Court says no, the matter should have gone before the High Court only. And then when I again move the High Court, there is again no discussion how long the trial will take.
Considering that there is evidence of eyewitness,
No, yes.
Injured
Of the
comma,
end of the
injured eyewitness, comma, CCTV footage,
No. Lord, I'm not denying.
Against the petitioner who has allegedly stabbed the deceased on his abdomen.
Please have the statement of the
And
injured
moreover,
at page
petitioner has
45.
7 criminal antecedents to his credit. We are not inclined.
Lord, page 45, your lordship may
We are not inclined to entertain this SLP accordingly. SLP is dismissed. Yes, next.
Lord, my humble request, at least a report may be called from the trial.
Okay,
court.
thank
How
you.
long the trial will
Over, it
take?
is over. Next.
Item 47, it is for suspension of sentence and for grant of bail, Your Honor. Arrest order defect.
Dead body was recovered at your instance.
Grave offense.
Dead body was recovered at your instance.
No, Your Honor, but only
For an early hearing of the appeal. Earlier
previous
appearance, physical appearance.
This is a fresh matter, Lordship will have.
In 46, you are saying?
Yes.
Lilin. Yes.
Very grave case.
Yes.
Your Honor, my CDR location was not found there.
You argue the
Argue the appeal. Argue the appeal.
Your Honor, kindly give us that we will want to file additional documents.
We don't need, Mr. Counsel. These documents are sufficient to convince us.
Dismissed.
Item 48.
Your Lordship, I have been under judicial custody since 9th of
In 4 weeks.
Lords, I appeal to the state, Lords.
Post on 11th March.
Lords, my
Yes.
appearance will be kindly taken.
11th week करना.
State of Bihar.
18th March. 18th to इसको लगाया. 19th March. Yes. Physical appearance ले लेंगे.
Yes.
Physical appearance waives notice. Undertakes to file. Yes.
Lordship, in item 15, Lordship issued notice in last hearing. State has asked for time to file reply, but
Yes, state. Pass over.
My lord, I need short accommodation, Lordship. I have received some injury. I could not file it.
You are appearing in 15?
Yes, Lordship. I am for the state. I received some injury. I could not file the counter. I am instructed that there are several criminal antecedents against
1
this,
week or 2 weeks? What?
3 weeks, Lordship. Give me 3 weeks time, Lordship.
Why 3 weeks? 2 weeks.
Okay, Lordship. I'll file it. I'll file
2
it.
weeks for counsel.
16.
Yes.
Your Lordship, this is a case for extension of medical bail that was granted.
Any counter is filed?
No, Your Lordship.
The counter was filed against the bail application. No counter.
No, in this SLP, further extension is sought.
Yes.
And my lords,
You should place on record his current medical condition so that we decide.
my lords, I am representing the victims. This was a firecrackers factory blast that
We
led
know,
to-
we know, we have
I
discussed.
filed an impediment application 42645 that may be taken on record. I've also filed my reply, my lords. That may also kindly be taken on record.
This is an indulgence only on medical
They
ground.
know.
Yes. My lords, the challenge is I was heard by the Supreme Court. Even
When have you filed this impediment?
we have already filed, my lords. It's
Already
number
means
42645.
tomorrow, yesterday or day before?
Yesterday, my lord.
Yesterday it may not be.
But my lords, it has already been cleared by the registry. I have the
Come up, come up.
Yes, very well, very well.
Deciding the matter today.
Yes, very well.
Yes. Let.
You file the present status report.
Let.
And you also filed a reply, my lords.
Let respondent state of NP file counter affidavit mentioning the present medical status of the medical condition of the petitioner.
Great.
Yes.
Your Lordship.
But at least my employment may be mentioned.
Yes, yes.
Your Lordship, in the mean-
So and so learned counsel submit that she has filed
IA number 42645, my lord.
IA number
42645 by
445 seeking impediment.
along with the reply.
Let the impediment application be also posted for consideration on the next date of hearing.
Also, short date may be given.
Short date, what's
Your
on?
Lordship, in the meanwhile, the impediment may continue.
9th March.
Great, my lord.
Interim bail. In the meanwhile, interim bail allowed in favor of petitioner shall continue till the next date of hearing. Yes. Yes. Yes, Mr.
Where is the 164 statement of the girl? 183.
That is not.
He has already filed an affidavit.
Victim has already.
Of the claim. On the
Father of the victim is here.
yeah, he will also support. You are supporting?
Court Millards, she has filed an affidavit.
All right.
Yes.
We are aware.
That medical report is also in my.
Forget about medical report.
It is only for that
She's married.
we implemented the father of the prosecutor so that we know whether at all
The affidavit was under
the
pressure.
affidavit was under pressure or it was free from pressure.
Yes. She's
Next. Concede, we have heard the counsel, Mr. So and so and counsel for the petitioner, Mr. Anand.
Yes.
Then counsel for the petitioner and Mr. So and so for the estate and Mr. So and so as well appearing for the respondent number 3, father of the prosecutor.
Victims.
With the victim, father of the victim. Full stop. Considering the entire fact situation of the case and the flip-flop
Item 18.
Your Lordship, I beg to appeal for petitioner, my lords. Lords, I was acquitted of the POCSO charges.
Yes.
I've been convicted under 3.
Where they were in relationship for 2020,
4 years.
2024.
is allowed and the petition is directed to be
नहीं, उसके पहले
we are of the considered view that the present is a fit case for
Yes,
suspension.
on the considered view, comma, on the length of jail sentence already suffered by the petitioner
Lordship, may I kindly,
and other attending circumstances. Yes.
Lordship, may I kindly record it was consensual relationship on the pretext of.
Oh, forget about it. You want a decision of the appeal at this stage? Let the High Court have its discretion.
Yes.
Great.
My lord, there was some delay. There was some delay in filing the SLP.
Delay करना.
Item 19.
Yes.
My lords, I am appealing for the state. We are seeking some time to file counter.
But complainant is you should implement complainant. Though you are enjoying interim order, we have granted.
Yes,
But they, since your statement was there that they have compromised
They have
and he has received the entire amount, complete the complaint so that he is here to confirm your statement. Let the complainant be made a party respondent in this SLP. Counter affidavit be filed and notice is issued to the complainant. Memo of parties be corrected. Whereas the next step, counsel is allowed 4 weeks time to file counter. Post the matter on 23rd March. Interim to continue.
Item 20.
Yes.
21 This is a matter of
20.
20.
Yes.
There is not a single eyewitness of the alleged incident, my lord. But there is not a single eyewitness.
Not a single eyewitness.
Second, that motive is also not proved. And I am implicated only on the basis
Antecedent, including 302.
Yes, only on that
Including
basis.
302.
Only on the basis of that antecedents I am implicated in the matter. The second aspect of the matter is that on the that
CCTV is there. You were roaming around.
So 58 2000.
What is the distance between the place of occurrence and the toll plaza?
That distance?
Yes.
That distance, Lord, I am not aware about that.
You have to make a statement on that.
But only, but that second aspect of the matter is this: only on the basis of antecedent, the police authority implicated me in the present matter. I was taken into custody on 5/8 on the basis of that CCTV footage, and that produced me after on 9th. The remand report is very much clear. That is the another aspect of the matter.
What is the remand report?
Remand report said that on the basis I was moving suspicious on the toll plaza.
Where is the remand application?
Page 41 is 39 starts, my lord.
Yes. What do you want to read from that?
41 second paragraph, my lord. While local police crime branch so and so, and we along with our subordinate police staff were investigating the said crime, an individual named petitioner was seen under suspicious circumstances on a motorcycle on 5/8 near the tea stall at the toll plaza on the way from Pune to Nashik. Upon further questioning, he gave evasive answers. As suspicious grew, he was taken into custody and brought to the police.
On 9th.
Taken into custody on 9th.
They are showing that they on the arrest form, my lord, they
9th August.
yes 9th August. But I was taken into custody on 5.
It's a case of 4 days illegal custody.
Yes.
He was not taken into custody on 5th.
Oh, he was confined on what ground for 4 days? Did you release him?
Lord, he was taken into custody on 9th, not 5th.
Read page 41, Mr. Counsel.
41 says
when did you release him? Read page 41.
Lord, 41 says what my learned friend has read. That.
Yes, read that.
Lord,
He has taken a specific plea.
Where is the fact mentioned in this that he was
Released on after
he was
5th of
detained on 9th, not on 5th. Detained, not arrested.
Detention is on 5th August. You continue to keep him confined for 4 days.
No, this says on 5th. On the basis of CCTV, he was moving
He
around.
was detained. Read please page 41.
While the local crime branch Ahmednagar and we along with the subordinate police staff were investigating the said crime, an individual named Bhushan Wale was seen under suspicious circumstances on motorcycle on 5th so-and-so at 3:30 am near a tea stall at toll plaza on the way from Pune to Nashik. Upon further questioning, he gave evasive answers. As suspicion grew, he was taken into custody and brought to the police station. Upon questioning him in confidence, he confessed to
What is this date? He was taken into custody.
When was he brought
What
into
is this
the
date?
police station?
Lord,
So from 5th
verify
August
this,
to
Lord.
9th August, they have taken a specific ground.
Lord,
What have you replied?
Lord, as per my Lord, instructions, my Lord, he is.
Does this document read that he was released thereafter and was asked to come
You
back on 9th?
satisfy us that he was taken into custody on 9th itself and not on 5th.
The document itself reads so. Where is your ground, Mr. Counsel? To this effect that he was kept in legal custody.
Yes, page 4 of the inquiry note.
Yes.
Para 4.
Yes.
Learned advocate for the appellant submits that.
What is your reply to this?
Non-communication of grounds of arrest for 4 days.
Yes.
Yes.
Lord, I have stated that he is taken into custody on 9th itself. my
What
Lord.
were you doing with him since 5th to 9th, Mr. Counsel? That's what we are asking. How was he kept confined for 4 days without preparing an arrest memo?
Yes, what has
But he was not confined. He was arrested on 9th itself. my Lord.
What were you doing with him from 5th? Please, your document remand form says.
specifically page C, last paragraph, petitioner was taken into custody on 5/8. What is your reply to this? Because the remand was taken on 10/8. That
Yes.
means he was arrested on 9/8.
Arrest memo itself is of
From 5th to 9th,
he was in illegal
he was in
custody.
illegal custody, and you have not replied to this specific.
And grounds of arrest? Nothing.
Lordship grants me a week's time.
No
to rectify
question. No
this.
question. Sorry.
Take heard and counsel for the parties. Considering the material on record, and for the fact that petitioner is in custody for more than 1.5 years, we are inclined to release the petition on bail. Accordingly allowed.
Great.
Seeking a short passover in this matter, Your Lordship. We are led by Senior V. Giri. He's on left.
Yes.
Passover.
Passover.
Item 22.
It's point 2 to 4.
Yes.
Made. Sorry. While issuing notice, please see the order which has been passed.
No.
29-4.
You want to argue? Come on merits.
No, on merits only, Lord.
Yes.
On merits. Please come to the order
No, you convince us.
Just 1
You
minute.
are a developer.
No, my lords. I'm the original owner. Please come to 29.4 for a minute, my lords. My lord's order. It is the contention.
You will not argue.
No, I'm arguing, my lords.
Yes.
It is the contention of the petitioner that the award notice was defective and the award is passed beyond the stipulated period of 2 years. Delay condoned, issue notice, etc. Now, it was my specific, my lords have the 29.4 order.
Yes.
Now, it was my specific case before the High Court that the award was 2 years beyond the Section 6 declaration. And therefore, the whole thing lapsed under Section 11 capital A. Specific ground was taken. No specific answer for that issue. In fact, that ground, if my lords will see, is that in the writ petition.
Which order you read?
29.4, 2024 of my lords, while issuing notice.
ये ना आरोपी नहीं है.
May I pass on?
Yes, yes. अच्छा आगे पीछे लग गया.
First para, my lords. It is the contention of the petitioner that the award notice was defective and the award is passed beyond the stipulated period of 2 years, delay condoned, issue notice, etc. Now, this ground was specifically taken in the writ petition. Please come to writ petition at 99, specifically the grounds at 108. Please come to that for a minute, my lords. 99 it starts. Act, my lords, 108, para 16. Bottom of para 16, the award notice, last line, my lords, last 3 lines, in fact.
Yes.
Is also defective and the award is passed beyond stipulated period of 2 years, which again is contrary to 11 capital A of the Act. Now, apart from this,
what is their answer to this?
No specific answer to this.
Let us see the counter first.
Yes.
The writ petition.
Yes.
Yes.
Now, please.
Because the High Court has not dealt with this.
It has not. That's why, my lords, we specifically pointed it out. One more aspect. I also raised the ground that the time period between 4 and 6 also there is a delay. That is not taken note of by the High Court and they deal with that. Now, please come to page, the impugned order, page 23. It is to be noted, last paragraph. It is to be noted that no other ground is urged seriously, but on going through the learned single judge's order, the petitioner has taken a contention that the final notification is not published within the time prescribed. Single judge has considered the same at para 10 of the order, taking note of the fact that the publication at Satur village by the revenue inspector is on 16/12/2010 and final notification is on 15/12/2011 and rightly held that the final declaration is within the time prescribed. So of the 2 points raised by me, the first point with regard to 4 and 6 is looked at. Now, please see what they say in the counter before my lords in respect of this point. Please come to that. For the first time, a document has been produced and High Court has really not looked at it. And we have not had the opportunity to rebut it. Therefore, perhaps appropriately, it may be a case for to go back to the High Court.
Not go back. We'll decide here itself. You file your reply to this. If they have filed it now,
yes,
you can file additional affidavit.
Sorry to interrupt. May I just point
out? I want to point out something.
This, I'll answer on merits. It's covered by a lordship's judgment, but this is not even a ground raised in the SLP. Although, because it was there in the notice, order issuing notice, we have referred to that. The single judge, my lords, refers to this argument at page 151, rejects this argument. Before the division bench, it appears to have not even been raised. In the SLP, in the grounds, not a single ground on this. While issuing notice, this they appear to have taken this. Please have page 151 first. And covered by a lordship's judgment. I'd show the judgment straight away.
Can I then point out their objections before the High Court?
Page 150, bottom of the...
If you wish to file any additional
There is
affidavit,
a specific ground.
I will file, my lord.
Otherwise, don't waste time and then after 10 minutes you will say, allow us time.
Very good. We'll do that. I'll do that.
Your lordship is referring to page 23.
Wait a minute.
In view of the additional document filed by respondent, the learned counsel for the learned senior counsel appearing for the petitioner seeks time to file additional affidavit. Accordingly, post the matter after 4 weeks.
We'll do that.
Post the matter on 10th March. sorry, 19th March.
I'm sorry, is there anyway, that ground is there anyway, I'll show you your lordship, it's covered.
I didn't want to say
No,
anything.
it's covered by your lordship's judgment. May I make one request though, Manoj?
May be covered, but since he will
Very
see time after half an hour, we know.
May I then make one
That's our
request?
argument,
This entire project of about 250 houses is stalled because of this, 2,500 houses is stalled because of the state.
We'll hear it next.
Some date if your lordships.
My lords,
Date already given, 19th March.
yes. I'm reserving myself on the last submission also, my lords. We are disputing it. Anyway, my lords, I'll file my affidavit and we'll argue, my lords. Deeply obliged.
My lords, if permit me to submit hard copy of the appearance, my lords, for item 22.
Why hard copy?
My lords, names of two of the councils. My lords, name of one of the seniors, my lords, was missed on my part, and the application. So,
Item 23.
Yes.
Santosh Kumar is deceased on 13/3/2019, suicide note.
Where is the suicide note?
As per the suicide note, my lord.
Lordship, we have produced original version of suicide note. It is on page number 13 of counter affidavit. Mistakenly, he wrote Varun
Wait a minute.
Singh.
Even if we consider the suicide note on the face of it, whether it is
What
full
is the abatement? How will it constitute abatement?
He is clearly
That is 11 and 12.
he was being harassed by these people.
So he expected some monies, or some monies were due to the accused, due to be paid to him by the accused. So he should have filed a civil suit.
But this can
How it is abatement?
It is Varun Singh.
It's Varun
Singh.
That is what prosecution story is, that he mistakenly wrote Varun Singh instead of Varun Singh, and all the other co-accused.
Contents of the suicide notice, मुझे इससे इतना लेना है, मुझे इससे इतना लेना है, मैं रेत घाट से परेशान हूँ, परेशान वाले के नाम इस प्रकार है. So many lawyers are really perturbed because matters are not taken up. What to do?
May I know the page 30, Hindi version?
That's what we are reading. That's what we are reading. Irrespective, even if you had been named.
Even if it your name
This doesn't
and rightly named.
No suicide note.
This doesn't constitute a suicide note at all, as a matter of fact. हिसाब किताब बाकी का करना है और कुछ नहीं.
Diary. It is diary entry.
हाँ, diary entry.
Yes, where is the ingredients of the?
He has not clearly stating that.
नहीं सर, मैं मन से
not
परेशान हो गया, इसलिए मन से आत्महत्या कर.
अपने मन से.
Yes, yes. Para 14, page
Yes,
number 11.
page 30. मैं अपने मन से आत्महत्या कर रहा हूँ. This is हिंदी version.
So,
outstandings exceeded his capacity and therefore he's committed suicide. What to do?
because he was being harassed.
No, because
Every person with whom he has business transaction.
business transaction.
In upper portion of this note, he is clearly saying that he was being harassed by these sets of people, and at the bottom he is saying that he is committing suicide.
No, we'll pass a detail out. Allowed.
Lordship may allow to give the appearance slip in item 16. I appear.
Item 16.
Yes.
Item 24.
Also, I'm seeking the week's accommodation in this matter. My colleague who is arguing this matter unfortunately had some personal difficulty today. She could not appear.
2 weeks.
Item 25.
If you're not, I'm appearing for respondent number 315, the state of Gujarat in this matter. Will not be a preferred and one SLP in this matter. It's showing a date of 13. Defects are clear. Most likely it will be listed on 13. Let that main matter, this matter come along with this matter.
13th before us or before some other?
No, it's the same similar matter. State, this is the union's SLP. State of Gujarat.
State diary number. Diary number.
5138 of 2026.
Learned counsel for the petitioner submits that.
Well, it's, they are appearing for the state of Gujarat.
Gujarat.
I'm appearing for Union of
May I submit?
It should have appeared on this side.
In that case, state of Gujarat is the appearance. Petitioner before us. It is the same.
But who is the petitioner in this case?
I'm appearing for the petitioner Union of India in this matter. We're being helped by the learned solicitor general. Now let's take up both the matters.
Learned counsel for the petitioner submits that state of Gujarat has also preferred SLP diary number
5138 of 2020.
5138 of 2026. Again, the same implement. Tag with so and so.
Lordship, I am appearing for Gujarat Karamchari Anganwadi Sangathan, my Lordship. I was implemented as a party before the High Court, my Lordship, but I was not made a party here, my Lordship.
You file implement.
I file implement, record my appearance, my Lordship. Permit me to mark my presence.
You file. You are
file.
not yet a party.
Lordship, I was implemented as a party.
You are not yet a party in this assembly. How can we take your personal physical application?
Please, my lords, that matter is still, notice has not been issued in that matter. That matter will come up on 13. So, Lordship has stated that it is to be tagged in the order.
So then that will be tagged and listed automatically on the date which is its scheduled. What else are we supposed to do?
Then what
Other
shall
than
we
tagging?
write?
My lords, that
What shall we dictate that so and so has been filed? It will come up on 13. How do we know it will come up on 13?
Your Lordship, the private respondent have filed reply affidavit yesterday.
अच्छा ऐसा करना tag with नहीं करना also file so and so post this matter after 4 weeks.
Lordship, pleadings may be completed from the government side in this matter. The private respondents have filed reply affidavit yesterday.
If they want to file counter rejoinder, they will do it.
Yes, next, call the next case.
Item 46.
Lords, in item 26, we have been served with the counter on Saturday. Lords, we are seeking short accommodation to seek instructions in that. And
How much? 2 weeks, 3 weeks?
2 weeks, Lords.
2 weeks
And
for
it will
rejoinder.
be posted at any NMD for final hearing, Lords.
Yes.
Item 28.
2 weeks for rejoinder. Fresh case है हर आदमी को तुरंत चाहिए.
सर
Yes, ma'am.
सर एसआईटी ने जो भी रिपोर्ट फाइल की है मैं अपना रिप्लाई फाइल करना चाहती हूँ क्योंकि इवन
खत्म करिए इसको क्या कंटेम्प्ट है
सर मजिस्ट्रेट ने भी डायरेक्शन दिया था कि झूठे जो बयान दिए गए हैं वो आपने उसका स्टेटमेंट वगैरह नहीं लिया और मैंने इवन यहाँ पर भी सबमिट किए काफी सारे डॉक्यूमेंट एडिशनल डॉक्यूमेंट्स में जिसमें झूठे
Sir, actually conducted the
Sir, let me
investigation, my lord.
No, sir, let me speak.
He wants to file some rejoinder. क्या file
रिप्लाई फाइल करना चाहती हूँ आप
Right, no?
Objections against the state.
22 की एफआईआर की इन्वेस्टिगेशन की
IT report has been filed. Full stop.
और इसके अलावा
Petitioner appearing in person wants to file objection to the SIT report. Post the matter after 8 weeks. Yes.
Item 29.
8 weeks मत करना. Post the matter on जुलाई में करेंगे मतलब on 28 July.
Lordship, this matter is at the word of settlement. Now it is. Listed for mediation for signing of agreement on 11th March, Lordship.
On 11th March it will be signed.
Yes.
Yes. So we'll post it after 23rd March. Post on 23rd. At the joint request of non-counsel for the parties. Post on 23rd March.
Item 13.
Please. Yes.
Readings are completing this report.
Readings are complete.
Yes. Now kindly see my, I filed my counter
CPA.
affidavit.
Seeking transfer on what ground?
Seeking transfer on the ground, so the already 4 cases are pending.
4 cases are pending.
Yes, sir, in the Rohtak jurisdiction. Yes, sir.
May kindly see one more thing, Malay. Before transfer, Malay, the petitioner is appearing here.
All right, you are also appearing in Rohtak.
You are also appearing
The
in
problem is, Malay, I can't appear there because Malay, here she is appearing.
But you have not filed any transfer petition. Seeking transfer of Rohtak proceedings.
No, Malay, I have not filed.
Appear virtually.
If you can't appear,
she can appear here.
All right, you can appear there also.
15,000 I am paying, Malay, I'll be harassed.
Four other proceedings between the parties are
in mediation. Malay, kindly hear me.
We are inclined to allow this present transfer petition. Accordingly, so on.
Malad, in mediation, she said, I don't want to give you divorce, I don't want to live with you.
That is her problem.
Yes.
Contest.
May I please, Worship? Worship, there are two transfer petitions. One is filed by the wife, and this is the second one, which is filed by the husband. And Worship was placed to issue notice. So in the earlier transfer petition, that has been referred to the mediation while Lordship's order dated 29 January 2026. I'm just praying that this petition will also be tagged with that. And
Where is the ROP of the other matter?
Please, Worship, I'm having. This is the copy, order copy. And it is also mentioned in the office report.
P3. Annexure P3 is. See, I have file में annexure P3.
In TP civil number 2410 of 25, between the parties have been referred to mediation to be conducted by Supreme Mediation Center. Post office. Tag this petition with civil number 2410/2025 and the orders referring the parties to mediation shall also apply in the present transfer petition. Yes.
Pretty clear.
Item 32. Without checking this,
senior advocate is appearing before other courts, so we are taking part.
Requesting for a passover.
Appearing in other court.
Senior is here.
Senior is here.
Respondent for 2 minutes as per the last order was asked to file a counter minutes.
Who is respondent number 2?
Lordships, I am appearing for respondent number 2.
Yes. You have 5 counters?
No, your Lordships. Lordships may grant me time for 2 weeks.
She is ready to argue without affidavit. They accept me for the last date.
Yes. Are you ready to argue?
Lordships may grant me a passover, a short passover, your Lordships.
Passover? You will come here or what?
Your Lordship, my colleague is there in physical.
All right, so are you ready to argue or not?
My colleague will argue, your Lordships.
He is here, then why do you want to pass?
Not in this.
My lords, I have a certain difficulty for my daughter. If my lords can have it next time. Sorry, my lords.
Counsel for respondent number 2 pass over. Need 2.
You are for 1?
2 pass over. However, learned counsel for the respondent number 1 has some difficulty.
Your Lordship, my colleague is here.
I don't have my lords.
Representing the state is a complaint.
He is also
He
here.
is here.
8 minutes.
Yes.
No, but 2 o'clock. My file, my clerk is getting my file. I'll also pass it over.
He is here.
Clerk is also here.
So sorry, miss. Please have page 159 minutes.
Yes.
You don't want the petitioner to argue the case?
No, I'll leave it at that.
Then?
Yes, Mr. Nagam.
If they want for you have to kindly pass or I will do that matter. I am ready. If they want, can go ahead, Mr. Lawyer one.
No, we don't know who is seeking passover, either you or respondent number 2, respondent number 1.
No, I am not asking for. I am not asking for.
Yes, now he is ready. Yes.
Ready? Yes. Not me. The case
That 138 is pending?
Yes, my it is pending. Yes.
And it is this same transaction. Same transaction.
Yes.
Let both the matters be tried together.
What's up?
Let both the matters be tried together.
What's up? I will show my say how.
You see, what is his defense is your offense and your offense is his defense.
After he appeared, he made a complaint. The police inquired into. Police found that there is no proof.
Suppose
yes,
their defense is accepted and your 138 fails. And if in the meanwhile we quash this trial,
yes,
then what will happen?
Perhaps this has to be what the reason is this. Muratma kindly consider. He made
How do they-
the trial is stayed.
Trial is-
This trial has been stayed. Yes. Leave granted. Post for final hearing in due course. The interim order shall continue during pendency of
It won't
the
come in the near future.
Yes.
It won't come in the near future.
Let it be, you
No,
prosecutor.
in the meanwhile, 138 will come to an end.
If they
138
get
will come to
admitted,
an
they'll
end.
move an application. Simple as that.
Deeply very
Complaint filed by the petitioner under 138.
Shall not impede the trial
The stay may continue.
or offense under section 138 NIA
Filed by the petitioner.
filed by the petitioner, appellant. Yes.
In 33, before my friend begins,
So the interim stay may continue.
We already continued. Yes.
in item 33, before my friend begins, I have filed my counter this morning. If my lord could take it up next week.
Yes, sir. The only issue is.
Your counter.
Counter, I filed it this morning. I received late. The fault is entirely mine. If I could be accommodated by 1 week.
Your rejoinder is not required.
Yes, not required.
Let the counter filed by the respondent be placed on record. Yes. What do you say?
Page 17 of the impugned order, paragraph 16. The government in charge and responsible is not found in the complaint is a finding. Whereas in page number 58, paragraph 2, there is an averment. If every person is in charge and responsible, is C. There is an allegation. Your lordship may see. No,
We are not seeing. Why are you arguing when he is not in a position to argue? We don't have the counter.
This is a society, not a company, Mr. Counsel. This is a society, not a company.
Yes,
The concept is different.
Section 305 of the.
After 2 weeks. Yes.
I'm sorry.
Any specific.
It will come immediately after 2 weeks. Yes. Date doesn't. Some date.
Next
2 weeks ke baad. Yes.
May it please your lordships, my lords, I beg to appear for the petitioner. I apologize for appearing on the virtual, my lords. There was some personal difficulty today. I could not come immediately to the court. My lords, the counter has been filed. If lordships wants, I can place the impugned judgment before your lordships.
Huh?
I can start my lords on virtual mode, my lords. I can put the. I'm ready to start, my lords. I just wanted to apologize for being on virtual mode, my lords. That's it.
You come and argue physically.
My lords and lordships may have it on Tuesday, my lords. So I'm sorry, my lords. There was some bereavement in the extended family. I have to go there, my lords. That's the only reason I could not come. Lordships may have it next Tuesday. I'll be there physically.
Difficult.
That's why I apologize in the beginning, my lords. It's an unforeseen circumstance last night, my lords.
Learned counsel for the petitioner wants to argue the matter physically. Post the matter on 10th March.
My lords, may I just make a request? Although it is on the adjournment, is at my behest, my lords. The trial court is insisting on my appearance, my lords. Lordships may only. Say that very well, my lords. I'll not push for it, my lords. I will be there on 10th March. I'm sorry for this one.
Item 35.
Yes, my lords, I appear on behalf of the petitioner. The state was to file counsel on the last date of hearing. It is yet to be.
No. 70 years से कैंसर हो गया बोलता है.
Surrender.
State. PC it का है.
You're from.
You bring him.
Very well. My lord, anyway, a senior from Bangalore is to argue the matter. If it may be listed in the second week of March.
No, but at least
Very
he should
well.
say whether he wants to file counter or not.
Very well.
Whether record of the trial court is summoned.
Not so far, my lords.
Let him come. Let him come.
Very good. So great.
Pass.
To the cost. May grant me some. I'll file my.
4 weeks for counter.
Item 37.
My lords, I am appearing for the petitioner, my lords. I am requesting for short accommodation, my lords. The Argo Council is unwell, my lords. I am requesting for 1 week's time, my lords.
The state has taken the accommodation. Let me see the orders.
I'm just seeking for 1 week's time, my lords. That's
If
it.
you look at the last order was 6th of October, then universities granted them a last meeting. Even prior to that, on September, 9th of September also, they showed time universities.
I apologize, my lords.
2022, they are just taking time again and again. It's not a first of all.
My lords, I am requesting for just 1 week, my lord. That's it.
And may I be because I have filed my application for implement and direction. My grievance is just a second. My complaint is
if we are not able to decide in your absence, then we'll allow the implementation.
At least because for the last yes,
we are not satisfied with the assistance rendered by him, we will allow for implementation.
My case is not that. It's not simply sitter. In fact, I succeeded on the premise.
You convince him.
Other party, but
you convince him. Otherwise, we'll post it after summer vacation.
No, I'm saying
because if the implement is allowed, then he will file counter. Yes. Then a rejoinder to the counter, and it will go on.
The implement
at least 6 months package.
I'm only submitting.
Or else your lordship, I will not file any counter affidavit. Your lordship, just because I am similarly placed, I have my writ petition is allowed.
What for you are filing implement if you don't want to file any counter? You are supporting the state or the
respondent.
He is already protecting his interest.
My problem. 1 minute.
Application for implement is rejected.
No, your lordship may not, because I have already my petition is allowed on the basis of an impugned order. When that order is not being implemented for the last 4 years, I filed a content petition. My content petition was not kept on hold because of the pendency of that's so difficult. In employment,
he wants to bypass that particular stage because state has filed an appeal against my orders. Now it is my petition.
You not say would just
anyway. We'll consider.
Please,
consider.
Please,
coming Tuesday. Coming Tuesday.
Please,
much over.
Grateful minutes.
Yes. Yes.
Announcement.
Yes. That is not here. Awesome.
Item 39.
39 is a contempt matter, lordships.
Yes.
Yes, lordship. Implement order passed by this court 2 years back. We are still struggling to get the order implemented.
Lordship, Lordship, may I mention, Lordship, I'm referring for the state.
Yes.
Clear-cut order and what we have
clear-cut injury. You see,
injury is there, lordship.
Lordship, again, Lordship, we have complied with the order. Only thing what is left is the some areas has
then how it is full compliance, Mr. Borakati?
Sir, my instructions are that it will be. It might have been already cleared. Give me 2 weeks time. I'll update Lordship with that.
Compliance affidavit. Affidavit he has filed.
Yes, please kindly come to page.
What remains to be complied?
He himself says that.
Devojit.
Lordship, some areas are to be paid to them. I am told that it is 2 weeks time. Lordship, I'll file affidavit on that.
And that is one aspect. And another aspect is everyone has been provincialized with effect from 1/1/2013. These 6 people have been randomly given a date 1/6/2016.
That would be a separate cause of action, Mr.
Lordship,
that can't be contempt.
So certainly, Lordship, because Lordship.
All right, let us file at least to get the areas, then we'll see.
Yes, very good.
Lordship, give me 2 weeks time. I'll do it. Lordship.
Sri Devojit
Borakati.
Council
yes, Lordship.
Contemner submits that What has been paid?
Pending areas.
Nothing has been paid. Not no idea.
Pending arrears shall be paid to the petitioner within 2 weeks, and he shall file compliance affidavit.
Lordship.
Post matter on recording the above submission, let the matter be posted on 24th February.
Much
Yes.
Grateful. Very good.
40.
It's 40 minutes. And there's 40. I'm entering appearance on behalf of some of the defendants. Look, this pertains to contempt.
Service is incomplete. Service is incomplete for respondent number 8 and 9. Both are deceased.
Yes.
Lord, may kindly permit us to take steps with regard to that.
Very good.
Let unserved respondent number, let fresh notice be issued.
8 and 9 died.
They will take a step for bringing alarms on record.
No, my lord, I'll take steps.
Then you will have to take steps. That's how we say it.
Let steps be taken for bringing on record the legal heirs of deceased respondent number 8 and 9.
Thus, in the meanwhile, I'll undertake to file wakalat on behalf of the defendant for which I have got malus.
Which respondent?
Defendant number 1, 2, 3, 5, 1, 2, 3, and Lordship 5, 6, 7. 8, 9 are no more.
1, 2, 3, 5,
5, 6, 7. I have got instructions.
What about 4?
Plus 4 is in hospital. I've been informed. I have oral instruction that I may get a wakalat on behalf of them also.
1, 2, 3, so. You have filed wakalat?
No, no, I have not. I'll file. I've got the wakalat. Let me file.
Learned counsel appearing for so and so. You want to file counter?
Malas, I want to say propose one thing, Malas. This pertains to the payment. Malas, there is one subsequent purchaser who was a party before the court in SLP also and as well before the High Court. Let him be implemented. He had offered to pay on because the property was.
Say so in the affidavit.
I'll say so in the affidavit. If you can
to file counter affidavit within 2 weeks. Put the matter after 3 weeks.
If he can be included, Lordship, he can pay the amount. That's what is our instruction because he has already given them offer. Now, as on date, my oral instruction.
All right, you take this plea in your affidavit.
All right, I'll take that. Very well.
And you think over it, Mr. Counsel?
It's a contempt petition. He has not committed contempt. Why should he be implemented?
No, Manas, because he was a party before this honorable court. Only thing in
whether the contempt is committed by him or by you.
No, by us. But
then how can we say?
Manas, I will propose.
Contempt petition.
Manas, I'll put that in affidavit.
You yes, an application if you want to shift.
See, contempt petition we can join anybody as respondent, provided we have an impression that he is also committed contempt.
He has not, but he wants to pay on their behalf because of.
Yes.
I'll put this in. Very good. Grateful.
Section 41.
Yes.
So the respondent on it.
Yes.
That's the charge sheet mentions the proposed punishment, and also I have not been given show cause to file my reply.
There is no inquiry without.
In 1983.
The petitioner 41. No one there. So password.
Item 47.
Yes.
Please, Your Lordship. The respondent is beneficiary of compassionate appointment, though he has been acquitted in that FIR subsequently. But the issue, my lords may have page number 40, that is the affidavit file. Pursuant to
he was facing an NDPS case.
Please, my lords.
It was disclosed also. That was disclosed.
That has not been disclosed. The FIR number and the trial has not been disclosed. It was disclosed in a very cryptic manner, though he stated that I am facing a trial, but in a very cryptic manner, my lord.
Verified. You should have verified.
My lord.
And acquittal is by what mode? Acquittal is a clean
acquittal after framing charges, my lord.
Is it a clean acquittal or what is it?
Yes, madam. It is an only acquittal. It doesn't say clean acquittal.
Where is the judgment? Where is the judgment of the
that has been placed by the.
See, otherwise there is no disqualification. It is not that he is.
application. It
My
was
lord,
page
page
8 of. Please, my lord.
1 minute, Mr.
Yes, my lord. Otherwise, my lord, he was entitled for compassionate appointment. He was granted also.
Page 40, he mentioned one case. You should have sought a better affidavit from him.
Correct, my lord. That should have been, but
Yes.
without having
It is
FIR.
not that he has tell this
FIR number he gives. He said that case is under trial. Then
No, my lord, he does not give FIR number.
Oh, please come page 41.
My lord, this is the report filed. My lord, page 40, para number 5, he discloses that deponent is under trial in one case, but the said case has not been disposed until date. So, my lord, the purpose of having this affidavit and a disclosure is giving clean number and details.
Little different from routine recruitment. Case of compacted appointment.
I have
and the
compassion
fact,
for him, my lord.
fact that he has been acquitted now. Mr. Counsel, Mr. Rana, have you filed the acquittal judgment?
Yes, my lord. My lord may see page 8 of the application for filing additional documents. My lords, we have placed it on record. Annexure A1, it starts at page 8. My lord, application for placing on record additional documents.
Let us see.
Page?
My lord, page 8, annexure A1.
This was on 7th October 2025.
Yes, my lord. Yes, my lord. And now my lords may see page 31, my lord, para 36.
So you were riding as a pillion rider. If narcotic was recovered from the pocket of the driver,
please, my lord.
And the
Yes, my
motorcycle
lord.
was owned by you.
No, my
You
lord.
were the owner of the motorcycle.
My lord.
And that person has been convicted, my lord.
Wait a minute.
Yes, my lord. That person has been convicted. In plea bargain, he sought lesser punishment.
Para 37.
My lord, para 36 at page 31, my lords. My lords, may I read para 36? In the present case, no recovery has been effected from co-accused Arsam Malik, nor is there any material to suggest that his conscious possession or involvement in
Who was
transportation.
the owner? Was the motorcycle owned by this this person? Was he the registered owner? Any finding to that effect? Any motorcycle confiscation का भी order नहीं है.
I don't think, my lord, that has been. My lord, the only connection which I was. My lord, the only connection was that the mobile tower location of both the A1 and A2 was one. To which
That obviously since they were traveling together.
Yes, my lord. To which the trial court said that merely because he was found to be in an area where A1 was also traveling would not be a reason.
No prior meeting, no prior knowledge.
Nothing, my lord. Nothing, my lord. It has been absolutely established that I had no prior connection with the first accused, and my lord, therefore, there was no credible evidence on record to show that the accused was involved in the transportation of the contraband by accused Mohammed Sohail. Mohammed Sohail stands, my lord, convicted.
All right, let it be.
Can do that. I have that compassion for him, my lord, that
Otherwise, also the acquittal is on the ground. If he had no knowledge at all.
My lord,
If the other guy was perhaps an addict.
Considering that the petitioner had, the respondent had disclosed one criminal case pending against him at the time of securing compassionate appointment, and in the said case, and at a later stage, he has been acquitted in the said offence. We are not inclined to interfere with the orders passed by the High Court.
Clean acquittal.
We've granted clean acquittal. We've been granted clean acquittal. We are not inclined to interfere.
Lord, just may request that if my lord may consider saying a line with regard to the salary which he may file a litigation.
Whatever the High Court has directed, we are not interfering.
What salary?
Please.
Salary for the period during which you are dragging him here. You should have thought it before coming to this court.
The idea was only just to avoid one more litigation.
Yes.
Grateful.
Very well, my lords. Deeply grateful. Deeply grateful.
43 notices were issued on 19 December. Somebody has entered appearance, they have to file reply.
Well, it's 2, 3, 4, and 5. Let's say I am appearing. I filed Vakalatnama yesterday, the day before yesterday.
Because I appear for respondent 1.
So I will file my counter, my lords. Should they give me some?
How much time? 4 weeks for count.
Yes, some date.
You will find a date after 4 weeks.
Yes. Plus permit us to give physical appearance.
Ah.
I have given.
Contempt petition, my lord, what would recall, my lord, 10th February 2022, my lord, this building got collapsed somewhere in Gurgaon.
What?
And 4th January order, my lord had passed an order.
Contempt petition?
Yes, my lord. So today happens to be almost 4 years for this building to get collapsed. And the builder has taken no steps, my lord. 4th January 2024 was the order passed by this honorable court. They have taken 18 months to apply for a permission, and permission has been declined for the reason that the form which they have submitted is not signed either by architect or by them. What kind of role is this, my lord? They are arm twisting all the owners. Owners are, some of them are staying there, some of them are vacated. Those who are staying there have no place to go. Rent was fixed at 40,000 rupees, my lord, which again they have not paid. This is the situation, my lord.
Yes.
I'm led by my senior. I appear for respondent number 1 and 2. They are also physically present here in court. I'm led by my senior, Mr. Atmaram Nantani, seeking a short pass over. But also apply is ready. We seek some time to put it on record.
You better place on record your affidavit.
Milord, if I may point out, Milord, I am appearing online for the state and the officers, Milord. Now, Milord, it seems the petitioners are the people, Milord, who are still staying in the apartments. As per the directions of my lords, Milord, in the judgment, contempt of which is being challenged, Milord, they were supposed to vacate it. Then the builder was directed to do the construction in a timely manner. We were directed to fix the rent, which we did, Milord. And, Milord, accordingly, they were supposed to get their flats. Now, Milord, it is not reflecting in the petition clearly whether these petitioners are the one who are staying inside the apartment and asking for reconstruction, or they have shifted from there, my lord. So first and foremost, my lord, they must clarify that. Apart from that, my lord, unless and until, my lord, the entire area will be vacated, it will not be possible for, my lord, either the builder or the state, my lord, to demolish and reconstruct.
Have you vacated?
Yeah, my lord, there are some of them have vacated, some of them have not vacated.
Then how that? Please give a pointed answer, counsel. Please give a pointed answer.
The builder has applied for seeking permission to reconstruct July 2025. Kindly bear with me. What happens is, my lord, so had I vacated, where do I go? He doesn't pay me the rent. He doesn't agree for the construction. He doesn't have permission. Now the final point. Final point is, he doesn't want to reconstruct the same tower. He wants the additional FAR to raise more flats there on the same property and then make money and also charge us for reconstructing.
So if he pays you the rent, you are ready to move out?
Yes, sir. Yes. That we have been telling him.
Milords, the 4-1 order against which there is contempt, if Milords may kindly read the order.
You read that?
Yes, Milords, the order says that I am supposed to pay the rent to them upon reconstruction. Milords.
No. From commencement of
not upon reconstruction.
Commencement of. So if you delay, you don't even seek permission to raise construction.
Milords, there is another matter before an alternate bench of my lords.
Forget about that.
And Milords, there is a stay that is
We are not concerned. We are not
Not
concerned.
payment of the rent.
We are not concerned.
Milords,
You can't do that.
I am led by my senior.
Stay at your instance.
Passover may be granted.
Okay, who has obtained stay?
Milords, there is this, Milords, in Shashikant matter.
Who has obtained stay?
Milords, the flat owners. Milords.
On what?
Milords,
My lord, there is another batch, my lord. There is another batch of petitions. My lord, if I may just give a background of the entire case.
We are
What happened
concerned
was
with contempt of our order.
only contempt, my lord. So, my lord, I request, my lord.
Forget about any other matter which is pending in different benches.
Definitely, my lord. Definitely. Now, my lord, how they are pointing
you
out.
file counter.
Yes.
Then they will file remand.
Yes.
2 weeks.
Sir, at least pass a rent order. People are from 4 years.
We'll do it in one go.
So, आपका order, like your order, in which 5 towers.
You have a lawyer appearing for you. I am the petitioner, sir. Every 4 years lawyer representing you, sir, they are
2 weeks for counter.
So at least pass rank.
1 week for yonder thereafter. Post on 12th March.
Very well.
Yes.
Item 45.
If for respondent's counsel, my lord, the respondent number 1 had met with an accident. Yesterday he has signed the affidavit. We will file the counter today evening or tomorrow early. 2 weeks time maybe.
Or counter.
Counter, my lord. For the
We are already signed. Why 2 weeks?
Affidavit has been, he has sent from Bangalore. We will file it today evening, my lord.
2 weeks for counter.
Grateful.
Item 50.
My lords, it's a complainant appeal. As per the last order, the state has to verify the death of our.
I appear for the statement. Unless the respondent number 1 has passed away, Manoj. I appear for the statement.
Respondent number 1 has passed away.
Yes, Manoj.
Yes. Appellant has also
That report is already there on.
My lord, this is a complainant appeal. R1 has passed away. R2, R3 are still.
Manoj will have to hear the appeal. For the other accused who have been acquitted, Manoj.
So, my lord, it's a criminal appeal. My lord, has to be put on.
Respondent number 1 has died. You are the
I'm the complainant.
Complainant's appeal against acquittal.
He is the only accused.
No, my lord. 2 more, R2 and R3.
My lords, I appear for R3, my lord.
1 and 2 in item number 50. 50. Respondent 1 has died. I am for respondent submissions. I do not know whether the death certificate.
What about respondent number 3?
My lords, I appear for respondent number 3, my
Death
lord.
certificate of respondent number 1 is filed?
Not yet filed.
Manoj, we are carrying
My
it.
lords,
Manoj,
I appear for respondent number 3. However, due
Carry
to
with you, file it in the
File
court.
it on record.
I'll have it filed.
It's not on record, but right now we have the physical copies, your lord.
You have already filed it?
Yes, your lord.
No, when?
But it's not on record.
When have you filed?
When did you place it on record?
Your lord, yesterday.
Yesterday.
Your lordship permitting, I can file it. Because
They have already filed it, Mr. Counsel. They have already filed it.
Office report says you have not filed any document.
Not filed.
Yesterday.
You have filed yesterday.
Yes.
Are you sure?
Yes, your lord. So yesterday.
Because the office report is also of 10th.
Let the death certificate of respondent number 1 be placed on record within a week. Post the criminal appeal for final hearing. After. Yes.
my lords, may I make a request as well?
Yes.
I appear for respondent number 3. We have not been able to get in touch with respondent number 3 for quite some time. If the state could also verify their status.
I will see when the matter is heard.
Grateful, my lords.
4 weeks का time है सर उसमें verification.
Possible matters.
तो फिर जाएगा.
Next, kindly appreciate there was a decree by the court.
2006, death has taken place.
And 7.
You applied in 2017.
No, 7. There was a decree, kindly see, there was a decree passed by the civil court, but in which SCCL was a party. And SCCL went in appeal, modified the order.
No, but on what date you applied? There may be a decree, but
immediately.
Immediately. Application. First application in 2007. So was that application. Because the finding is against you that you applied in 2017.
Page 43. So, where is that application of yours?
Application is not there, but kindly see page, my lord, it will page 50.
Where do you say that you applied in 2007?
Kindly see page 50, my lord. Page 50. SCCL went in appeal matrimonial challenge after
forget about that appeal. That appeal was not for complete appointment.
Kindly see this. I will read only two lines. my lord.
Cause of action may arise in your favor in 2007.
Kindly see this, page 50. Last line. SCCL went in appeal, modified their decree. Decree says you give the appointment.
Decree is to that.
And he said you go and declare your legal status. When it was a party,
Where is the decree?
page, can you see page 50, bottom line. Consequently, the appeal deserves to be allowed in the hereby allowed judgment passed by family court such and such in civil suit is modified to the extent that class 4 of the decree will not be binding of the appellant unless legal status of respond number that is legally valid by your side.
Finding it is
You get declare your legal status, and can you see according to decree in which the party Santi Devi was to be given compassionate appointment in compromise decree. 2007 court has passed order.
Where is that?
Page 45.
Kindly see
Page 45. Where is the declaration about your compassionate appointment?
In those
Kindly
who are working on post of friend, so the plaintiff Shanti Devi shall be rightful claimant to receive employment provided by so and so.
This is the decree. Compromise. So they got modified it. Well, get your declared your status.
After 8 years.
It is only enabling.
So directions.
Notice.
Did you?
Item 13.
Yes.
In item 13, my lord,
Yes.
surrender as per the last order of this honorable court. And in this case, the answer submission is the second.
No surrender certificate.
Yes, my lord, we have filed the surrender certificate. Also, office report also.
Case 320.
The honorable pleased to take the application and the surrender certificate has been filed. Well, the cases that section 399 on equality requires 5 and more.
You have fought on the spot.
No, my lord, that's the 5 and more. There were only the eyewitnesses, only one eyewitness, 2 are neighbors. The only eyewitness also says that eyewitness 4 person was there. My lord, just see 6 page 64, 67, my lord. Page 6 starts at 66.
Yeah.
Starts at 66. I just read it.
What is the finding of the trial court? Does the trial court say that there was one unknown man?
Well, yes, my lord. Trial court acquit 4th person, identity not established.
He ran away.
1 to 4, my
Ran
lord.
away.
Page 219, my lord. The trial court only 4, identity of person is not confirmed. This, my lord, the only eyewitness, page 66, the one who has filed the complaint also under this court. Only, my lord, he was 25 years old. My lord, only 2 months. My lord, I was throughout on the bail and exemption was granted to me. And I was 26 of 8, my lord, in 2011, my lord, under section 4 of probation of offender X, my lord. No antecedents, no, my lord, no antecedents throughout on bail, exemption, throughout on bail.
Considering that the petitioner was on bail during trial as also during pendency of appeal before the High Court, we are inclined to suspend the sentence and release the petitioner on bail.
Really good.
First up.
Leave grant. His name entitles him to bail.
Yes.
Accordingly, the sentence imposed upon the opponent is suspended. Released on bail, subject to the terms and conditions imposed by the trial court. Record of the trial court be summoned. Post the appeal on 4th May. Notice, it's a notice. It's a notice.
Surrendered in pursuance of the order dated 12/11/25 with the custody
Petitioner
certificate.
has already surrendered and surrender certificate is signed. Yes. उसके बाद इस notice.
Much obliged. Item 21.
My lord, I am seeking some accommodation, my lord. I'm being led by learned ASG is the way. I'm seeking a short accommodation, my lord.
Yes.
I'm being led by learned ASG. She is held up in court soon, my lord.
Yes. At the request of the counsel for the respondent post after 4 weeks.
Obliged, my lord.
Yes.
Can I file a list of dates and short submission?
Yes.
There are 3 or 4 matters.
Yes, parties may file list of dates and written submission. Yes.
Great.
Item 35.
My lord, it was passed over because nobody appeared on the file.
They are not appearing.
To file a
Let record of the trial court be summoned.
exemption from surrendering to continue, my lord.
Force the matter on 5th May. In the meanwhile, exemption from surrender allowed in favor of petitioner shall continue.
So great.
Item 38.
Lords, last date of hearing asked me to make some charge. Last date of hearing asked me. The case of amputation, my lords.
Amputation. Amputation of what?
Artificial limb.
Yes, my lord, artificial limb. And in one of the matter, my lords, you
are awarded 5,98,000.
By the
And
court
by the-
enhanced to 9,86,000, my lords. Tribunal was awarded
598, then 986.
986, my lords. The error is, my lords, High Court was taken only 25% of the disability, my lords, and the income was taken as 10,000, my lords.
What was your vocation?
I am a cook, my lords, in the hotel. I have not filed any.
Amputation is of leg.
Yes, my lords, I filed the photographs of, if you see the page number, my lords, photographs are already there.
You can leg amputation, Ms. Counsel, leg amputation can very well carry on the work of a cook.
That's
able to.
Yes, my lord. That's for artificial limb biopsy. Can you see the page number?
To travel a
Photograph
distance while cooking.
It is 28 page number. I have to stand long. Already 25%. But can you see the page number 28?
Counsel, there are people who are running marathons with both amputations.
That's I would like to show page number 28. My lords, that's here right now for the this artificial limb and expenses. I given a judgment of last hearing, my lords, where my lords the expenses of
artificial limb and replacement. That you will get, no doubt about it.
That's and disability, my lords. If it is considered that thing, my lords, it will be. I given a judgment.
12,500 has already been taken as monthly income.
The 18 accident, my lords. For chef, it was really very lower side, my lords. 8,000.
That was
and it's a 2018 accident.
Notional
minimum might have 25 to 30,000 everyone earns. Minimum even wages were taken.
So the income was
and
future prospect also 25% taken.
Yes, only 25%. And the doctor exactly given, my lords, is 70% disability.
Some you say. What more you want? 986 around, that means 10. We may increase by 2 lakhs more.
My lords, it will artificial limit will it's cost.
Replacement of cost.
What is your
one case? My lords have given 15 lakhs for artificial.
For that, I can read page number 37.
Required to be
replaced.
Regarding that, there is no
5 years.
This finding by tribunal, my lords. Page number 37, if my lords may have it. There is finding of tribunal, my lords, that the doctor himself has said that
page
37, my lords.
What has the doctor said?
My lords, I'll read it. Para 14.
You just state.
Lords,
need to read.
Doctor has stated that petitioner needs fixing of artificial limb, except the petitioner does not require any future treatment.
So obviously,
yes,
fixing of limb, that
which para you read?
His life has been compromised.
Para 14 and not
para 14 of the High Court.
Replacement,
yes, no, replacement
of the artificial limb.
Para 14 tribunal minutes.
It's a costly business. If you want a good prosthetic limb, it's a costly business.
These 5 lakhs by then, my lords, before the
judgment I given, my lords, there, my lords, refer the patient to the
seeking
My lords,
that future prospect.
future prospect is already taken, my lords.
Already taken.
Taken, my lords. So only
25%.
12,500, what the High Court taken it, at least, my lords, that took 15,000.
No, but what is the basis?
That's a cook, that's a, that
Cook, you have to have some evidence.
And please, that's why
On the date of incident,
that's why, my lords,
the
30,000.
minimum salary of a cook is 15,000.
That's why I'm saying 50,000.
12,500 is reasonable enough.
Notional income has been taken.
I will leave it, my lord. Notional income has taken, my lord. That's one. 15,000 will be correct amount in according to me. 50,000. Cook is anyone 25 to 30.
That according to
Can't
you,
be
it
random.
should be.
Can't be random. Either you come prepared with some judgment which says that the
judgment.
income of cook should be taken to be
I said
50,000.
for the cook, my level best.
What
But
about-
other things I have given all judgments.
What about the minimum wages act table? Do you have the table?
Yes.
Are you carrying the table? That would be. We may
According
take
to
him.
table only High Court.
We may take him to be a skilled labor. But then what was the salary at that point?
Because
As
High
per
Court
the
has-
table, 12,500 was the skilled labor.
12,500.
Skilled labor.
As per the Justice Karol's judgment is, my lords, as per the skilled employee, in 2010 accident, he is taken as a 12,000, my lords. I have a judgment in that point.
There is a table under the minimum wages act. We have to go by that.
You produce that notification. That is a statutory notification. We can consider that
A skilled.
if it is placed on record.
Tomorrow only I will leave. Tomorrow and next week, anytime.
Learned counsel for the petitioner is permitted to place on record
Skilled employees.
the notification as applicable on the relevant date, showing the minimum wage for a skilled laborer, that is a cook.
I left.
Yes.
Next week.
Post. Next week you want? Next week. Post in the next week.
I left.
Item 41.
Well, take it data.
For the respondent.
आज 10th ना 24th को करना 20.
Item 41 and for the respondent.
Post out में कोई नहीं था. Dismissal default करी होगा. वो है.
This is the case of
illegal termination में. RSRTC.
तो शर्मा तो खड़ा होता है.
नहीं शर्मा RSRTC.
Every term jurisdiction of the civil court has been upheld.
That's the only argument which
None appears for the petitioner in both the rounds. The SLP is dismissed for want of prosecution.
Right.
तो